Hi, it's Patrick Conroy, and we're on to Chapter 3, Finding and Analyzing Case Law. Being able to read and understand case law and finding it is essential, whether you're a paralegal or an attorney. And so I really put in a lot of videos to help really solidify things for you that go beyond the text. I encourage you to watch them all and learn from them because it will help you so much in life. Okay. So what is case law? Case law is a decision or an opinion written by a judge, i.e. the court, and it's considered primary authority. And it's based on precedent, meaning another court ruled on that same issue. And it often creates its own precedent. And it's published by order of court. So not every trial opinion is going to be published by the court, but all of the appellate by courts of appeals, Supreme Courts, those are printed. In legal research, we read case law to attempt to understand the factual and legal issues and how the court has resolved those issues in the past, because it sets precedent. Judges rely on previous decisions, the Constitution, statutory laws, and administrative regulations in rendering decisions and writing opinions. So they're going to be looking at all of those. And really, when you're doing your research, you're going to be the one who's going to be providing them examples that they should be looking at. So judges know that legal researchers read reported case law looking for opinions that may apply to their client's situation. So when they write it, they're very careful that knowing that what they are saying will be used by legal researchers and applied as precedent in future cases. That's why they have detailed facts and lengthy analysis of the factual and legal issues. So, review of stare decisis. It stands decided. That means that if another court has ruled on it, that court might be precedent. So, trial courts all have to follow the precedent set in their area that their trial court covers. Then if something goes to the appeals level, they have to follow what the appellate court has said for the appeals court's area. So that might have to be several district courts, across the states or parts of the country. And then if it goes to the Supreme Court of the state or the US, it affects all the courts in that state or the United States. So that's what it means by it only applies to cases within the same jurisdiction. So let's say Mississippi Supreme Court made a decision. Louisiana would not be bound to follow it. Now, if it went to the Court of Appeals for our federal area, and we're in the same area as Mississippi, yes, we would have to follow it. If it was, say, California, we wouldn't. But if it goes to the Supreme Court, then everybody has to. At the Supreme Court of the US, everybody has to follow it. And that's what it's meant by courts must follow case decisions of higher courts in the same jurisdiction. And that is mandatory authority. Persuasive authority might be a court that they don't have to follow, but it can be persuaded, you might be trying to persuade them to follow that court. They don't have to do it, but it strengthens your argument if there's no precedent following it. In cases, there's what's known as dictum and holding. Holding is the actual precedent. Dictum might be the judge going beyond the holding in what they're writing. And that can be used as persuasive authority, but it's not mandatory. The holding is mandatory. So the appeal process, I think this is a review for most of you. It's based on legal error, not a factual error. Trial courts decide the facts. Appeals courts, or if the judge in the other case made a legal error, That's what appellate courts are for. Now, appellate courts can affirm, reverse, or remand. Sometimes they reverse and remand both. Because affirm means the lower court was right. Reverse means the lower court was wrong. Remand means we're saying this back, so it might say we reverse this decision, and then we're going to send it back to the lower court for them to work out some other issue. An appeal is called a petition for writ or certiorari or cert, and U.S. Supreme Court is the highest. Okay, where to find case law? Case law reporters, volumes of books, Lexis, Westlaw, and Bloomberg Law. These are the electronic databases. There's some CD-ROM process, and there's some freely accessible on the internet. I'm going to have a second video where I show you a case in LexisNexis, and you can sort of see how it looks and where to find the good stuff. Supreme Court reporter, United States reports, that's what the Supreme Court. Unofficial reporters are these others. These might offer more explanation, but that's not the holding. They might try to explain the holding here or go into other depths, but those are unofficial. All these are other kinds of reporters. Then states, they have their official state reporters. And then the regional reporters are published by the region and cover multiple states. Federal and state case reports are found on Lexis and Westlaw. Most federal and state cases are found freely on freely accessible internet. There's no editorial enhancements such as headnotes, and I'll show you headnotes in LexisNexis. Always cite to original version, to official version. When you're reading a case, these are some of the things you will find. Facts. Judicial history. What did the lower courts say? How did it get to this appeals court? What are the legal issues? What are the rules that must be followed? An analysis, and then the decision. And sometimes you'll see the decision right at the top. Read topic. Now, this is a suggestion from the textbook. Read topic sentences first, and then color code different components and make margin notes. Well, don't be doing this in a book you don't own that's in like a law library. They don't like that. And then you want to be comparing the facts of your case to the precedent. Maybe you're going to contrast facts and say, hey, this case is different because in this case, the person that ran the stop sign had perfect vision. In ours, they were missing their glasses. Things like that. And some more Blue Book rules. Capital A court when referring to U.S. Supreme Court, not trial courts. Basic format again. Parties, volume, year, page. And state case law is cited in the same format that U.S. Supreme Courts are decided. Okay, so that's it for this lecture. I am going to show you next something in LexisNexis. So I'll be right back for that in the next lecture.